Welcome to our session on how to avoid unintended loss of firm authorisation. I'm Laura Barker, Head of Authorisation for Firm-Based Applications, and I'm joined by my colleague Shannon Heaney, who is a Technical Advisor in the Authorisation team. Just brief introduction into this session and why we're undertaking this session today. So authorisation obviously allows law firms to legally provide reserved legal activity in England and Wales. As a result, the consequence of losing authorisation can be significant and can mean that you're unable to provide legal services, which can harm your reputation and operational delivery. It's important to note that the legal regulations, so the Legal Services Act 2007, defines what an automatic loss condition is, and we have no discretion at the SRA in terms of that. So that's why it's key to understand the triggers and timelines that help firms to avoid unintended loss of authorisation.
So Laura has just touched briefly on the Legal Services Act. Now we'll be looking at some definitions that will be relevant to the loss of authorisation slides moving forward. So when we're talking about authorisation status, we're particularly interested in the structure of your firm, and that is specifically your managers and interest holders. So here we've got a couple of definitions of what we mean by that. So for a manager, we're talking about a director in a company, so that could be a limited company, a member in a UK LLP, so a UK limited liability partnership, a partner in a partnership that is not a body corporate, and for any other body, a member of its governing body. In terms of interest holders, you are talking about someone who holds shares in the body, or someone who is entitled to exercise or control the exercise of the voting rights in that body. Looking at the Legal Services Act 2007, it is Section 18 that defines loss of authorisation and how this will happen. So in a recognised body, they must have only legally qualified managers and interest holders at all times in order to be eligible for authorisation. If a recognised body acquires a non-legally qualified manager or interest holder, it will become licensable under Section 18 of the Legal Services Act. If it then remains licensable for a further 90 days, it will automatically cease to be authorised under Section 18(3) of the Legal Services Act. Moving on to licensed bodies then. A licensed body must always have at least one manager or interest holder who is a non-authorised person, or a manager or interest holder that is an authorised body in which non-authorised persons hold 10% or more of the voting rights. Yep. If a licensed body ceases to meet either of the conditions above, it is no longer licensable. Therefore, very similarly to recognised bodies, 90 days after it ceases to be licensable, it will automatically lose authorisation under Section 18(6) of the Legal Services Act.
So what we're going to do now is talk through some common scenarios, and the first one being in terms of recognised body. So these are genuine scenarios that we have encountered. All names of firms have been changed. So the first scenario is Sue Grabbit and Co., who appoint a non-authorised person as a salaried partner. Now, in this case, their COLP considered that that was okay, as he was not an equity partner. And as a result of that, their COLP decided they didn't need to take any action. Sue Grabbit and Co. loses authorisation. This is discovered 3 years later when an unrelated application is considered by our authorisation team. So in terms of why authorisation was lost in this scenario, it doesn't matter whether their partner is salaried or equity. They are a manager and therefore they will make the firm licensable. I'll hand over to Shannon for the second scenario.
So our second scenario then is another recognised body. The name of the firm we've used here is the Loan Litigator Limited. So the Loan Litigator Limited is a company with one sole solicitor director and shareholder. On the advice of his accountant, the solicitor decides to transfer his shares to a wholly owned holding company for tax purposes. Now, the holding company is a non-authorised person. As far as the solicitor is concerned, his firm remains wholly managed and controlled by him, and the holding company is simply in place for tax purposes. However, in this case, again, the firm lost authorisation. The reason that it lost authorisation in this case is because, as I said, the holding company is a non-authorised person, and its holding of the shares in the firm made it licensable under the Legal Services Act.
Scenario 3 is in relation to a licensed body. So Legal Intent LLP was licensed because it wished to make its office manager, a non-authorised person, a member and therefore a manager. This is a scenario that we see fairly often. She was the only non-authorised member of Legal Intent LLP. She's on the SILEX pathway to qualification and then subsequently is admitted as a chartered legal executive and given a practicing certificate. She then becomes an authorised person. So authorisation was lost here as it has no non-authorised managers or interest holders and therefore ceases becoming licensable. It took no action itself, which led to this result. So it doesn't realise that the implication of its own authorisation of the office manager becoming an authorised person.
Okay, so scenario 4 then is another licensed body looking at Clause for Concern Limited, which is a company with a sole solicitor director and owner and is licensed because that sole solicitor director is giving 5% of the shareholding to her husband, who is a non-authorised person. He is not an owner and has no practical involvement in the firm. The business is then later sold to another solicitor with all the shares transferring to him. In this case, authorisation was lost because on the face of it, it appeared to be a single solicitor business. However, it doesn't occur to the new solicitor that there is any regulatory impact of him becoming the sole director and shareholder and losing the 5% shareholding of the non-authorised person. In this case, the firm lost authorisation because its only non-authorised interest holder, who was the husband of the original solicitor, has ceased to be a shareholder and therefore the firm has ceased to be licensable.
The purpose of this session is to give you an idea of how unintended loss of authorisation could occur. And what we want to do is make sure that you speak to us before that happens. So please have a look at our website and make contact with us if you've got any concerns of the issues that we've discussed today.